It was July 25th, 2014. He was returned, I think it was from the Behavioral Health Center where he had been treated, and at that time he was found to be competent to stand trial. At that time, the defense raised the issue of the defendant's sanity. It was October 16th, 2014. We had another hearing, and I think the defendant, the report received from the Forensic Psychiatric Center of Northeastern Ohio indicated in the examiner's opinion that the defendant was not sane at the time of the alleged crimes. So this matter has been set today for technically a trial on the charges. The defendant has indicated to the court that it was his intention to file a jury waiver in this case. So, Mr. Pollock?
Yeah, I've got the jury waiver here. My client's indicating he's going to sign that. Can I have my copy on cuff so I can sign this, Judge? I have the jury waiver signed by the judge.
All right, when you hand it up, please.
The waiver reads as follows. It says, I, Reshad Riddle, the defendant in the above case, hereby voluntarily waive and relinquish any right to trial by jury. Fully accepts it. I just want to be sure that Mr. Reshad, you're waiving your right to a trial by jury voluntarily. Has anybody made you any threats or any promises in order to obtain your waiver of this jury trial right? Okay, and you understand that if you were to be tried by a jury, the jury would consist of 12 different people. You would have some input in the selection of the jury. The original list of potential jurors is selected by a computer. So nobody in this courtroom, the judge, the attorneys, nobody selects these jurors beforehand. There's a computer that goes through a list and picks out the names. But if we were going to have a jury trial, we'd probably call in 40 or 50 prospective jurors, and then we would question them, and both sides would have to be in agreement on who would serve on that jury. But you understand that if you waive the jury, you're going to make the judge now the finder of fact, that I'll make the decisions instead of a jury of 12 people. And you should keep in mind that if you were being tried by a jury, before you could be found guilty of anything, all 12 jurors would have to agree that your guilt had been proven beyond a reasonable doubt. Before you could be acquitted or found not guilty, all 12 jurors would also have to agree unanimously that your guilt had not been proven beyond a reasonable doubt. Right, and I assume you have talked to your attorney about this?
Yes.
Okay, and it's your decision then, voluntarily and knowingly to waive a jury and to consent to be tried by the court?
Yes.
Okay. The court's satisfied then if the waiver that's been submitted to the court is being tendered intelligently, voluntarily, and knowingly. I believe Mr. Riddle does understand the concept of the jury trial, and he's made this waiver in open court. Courts viewed him when he signed the written waiver. It's in writing, and the court will order this filed with the clerk of court. So I'm going to hand this to the bailiff and instruct her to go down and file this at this time with the clerk of courts, and you can make copies of that for both sides and the court.
I respond to calls for service, conduct investigations.
Yeah. All right, you proceed.
Were you working in that capacity on March 31st in the year 2013?
Yes, sir, I was.
You recall what shift you were working?
I would have been working the day watch, which would be from 7 a.m. until 7 p.m.
And do you recall if that was a particular holiday?
It was Easter Sunday.
Okay. Watha Church of God in Ashtabula City.
Yes, sir, there was.
And can you tell me why you were called, or how were you called to the church?
We were dispatched to the Hiawatha Baptist Church in reference to essentially what was reported to us as a man inside the church with a gun.
Okay, and where were you when you were dispatched?
I was actually at the station house, and I fielded one of the phone calls.
Okay. Did you respond?
I left immediately.
How did you get there?
I took the route of West 44th Street to Station Avenue, north across Route 20 to Station Avenue, and close to the intersection of West 34th.
Were you in a marked cruiser?
Yes, sir, I was.
And were you in uniform?
Yes, sir.
And how long did it take you to get from the police station to the church?
Probably about 2 minutes. I managed to obtain a brief description of the person who was inside. They informed me that it was a black male with a handgun and that he was currently on the altar or the podium area of the front of the church.
Okay, and this was while you were still on the outside of the church.
This was still on the outside.
While you were on the outside of the church, did there come a time that any other police officer or emergency personnel arrived?
Yes.
Who was that?
Officer Tom Clemens, Jr. Had arrived 10 seconds to 15 seconds prior to me, and I heard him call out on the radio, and he had arrived on the east side of the church in the parking lot area.
Okay, so you're on the west side, he's on the east side. Do you have, did you see him?
I did not see Officer Clemens until I made entry inside of the church.
Okay, so you entered on the east side of the church through a man door?
I went through the west side.
West side.
Through a man door, yes, sir.
Okay. And when you initially went through the door, what did you find?
Initially, when I went in, I could see Officer Clemens directly across from me in the church.
You're not the evidence officer, correct?
That is correct.
State calls Officer Tom Clemens. In a case such as this, or in any case actually, that once the crime scene's processed, that all the evidence is collected and taken into the custody of the police department, correct?
Yes, sir.
And that would include the gun.
Keeping the weapons out and laying them behind me. During that time, the radio officer Perry was also on scene, advising that he needed help in the back of the church outside, that he did have a subject down, and was asking for an ambulance also, if I recall.
Okay. Was anybody inside the church shot?
After securing him and dealing with some chaos inside the church, I escorted him up and out to my vehicle and secured him. Went back inside while officers were watching the subject in my patrol car, and began clearing the church. Nobody else was inside injured that I can locate.
Did there come a time when you actually transported? Were you able at that point to identify who this black male was?
Once I had him prone down in the church, I recognized him.
As who?
Mr. Riddle.
Okay. Is he in the courtroom today?
Yes, he is, sitting next to his attorney.
And when you say Mr. Riddle, you mean Mr. Reshad Riddle?
Correct.
How's he dressed? How's he get up? How's he dressed?
He's wearing a county fatigues, black and white stripe.
All right, let the record show he's identified the defendant in this case, Reshad Riddle.
So you transport him back to the police station?
Right, advise him his Miranda rights while he was in the back seat of my car, and then transport him to the police department.
Okay, and once at the police station, what did you do?
At that time, I brought him into a holding cell, placed him into the holding cell, took his jeans. He remained handcuffed behind his back. At that time, I had the chief of police meet me in the back, along with Sergeant Mark Allen from the Ashtabula County Sheriff's Department.
For what purpose?
At that point, we wanted to perform a GSR, gunshot residue, on the suspect's hands.
Okay, can we quickly explain what a gunshot residue test is?
You swab the suspect's hands. At that time, it's sent to a lab to indicate powder.
Okay, and did you perform the test on him?
Yes, I did.
And tell us how that went procedurally.
While doing the test, opening the kit, Sergeant Allen was standing to the left of the defendant or suspect, and he continued to talk while we were speaking with each other about the kit, opening the kit, and performing the swab on the hand, at which time I believe I was speaking to Sergeant Allen to which hand I was going to do first, and that's when the suspect spoke.
And what did he say?
He said that he shot his father with his right hand with the Smith & Wesson Model 10 revolver 38 Special.
What did you do after that?
I just continued to swab his hands, secure the kit, and he continued to speak.
Now, generally the evidence, the GSR evidence, the gun and all that, what does the police department do with that once it's been taken into custody?
That's usually processed, sent down to BCI where it's processed. As far as I did not secure the pistol, I believe Lieutenant Dibble responded to the scene and recovered the weapon. I just placed the kit into evidence for testing.
All right, that's all the questions I have. Thank you.
Mr. Pollock, anything you'd like to ask?
Just real quickly, Mr. Riddle talked about the Quran all of the night when he was talking to you.
Yes, he did.
Okay, and he was saying that was the justification for what he did, am I right?
I'm sorry, can you repeat?
He was saying that was the reason why he did all this?
Just kept making quotes from the Quran and speaking of Allah.
Okay. Hey, brother.
Any redirect?
Nothing, no, Your Honor.
All right, that'll be all. Thank you, Officer.
Thank you, sir.
We are also agreeing to stipulate to all BCI results regarding the gun, the operability of the gun, the caliber of the gun, and the results of the gunshot residue tests.
What were those results?
Yeah, we better get those marked, and we'll stipulate to them. I've got them on discovery. Sorry. I'm going to stipulate, I just wanted to
Did not
make it.
talk about that.
You've got to do more than just stipulate the results, because I don't know what the results were. I mean, you either got to put the report in or verbalize the results. But,
Well, I can verbalize the results, Judge.
well,
Unless you want to take a break, I'll get all the exhibits and mark them.
Mr. Pollock, what would you prefer? The
I have no
exhibits?
problems with the short reads. I just want to check if you said the record, so I keep it kosher.
Okay, on the record.
One at a time, please.
I have no problems with short recess if he needs it to get those exhibits marked, because we'll stipulate to their entry anyway.
Do you have copies available?
I have those, let me get them, let me get those for you.
This is out here.
All right, we'll wait for a minute until she has an opportunity to copy those documents.
States Exhibit 1, which would be the BCI report testing operability on a Smith & Wesson 38 caliber double action revolver, that it had been test fired, and that in fact was the make and model of the gun and the caliber of the bullet.
And that report indicated the gun was operable.
Yes, it does. And States Exhibit 2 would be the DNA results also from BCI, showing that the DNA from the gun matched the DNA of Reshad Riddle.
Okay, that's it? Those
That's-
three?
Yes.
All right, so stipulated, Mr. Impala?
So stipulate, yeah.
All right, then the stipulations, one regarding the training of the police officers, second stipulation regarding exhibits 1, 2, and 3, and the findings that were just reiterated by counsel are all stipulated to by both parties, and the court will admit them into evidence. He came and asked us whether he had the guns, was called out, and came out, showing us those evidence of that, or is it, you're gonna have to court any other stipulations or agreements here? Yeah, if there is a stipulation, you got to put it on the record.
Well, Your Honor, by agreement, it's the state's understanding that the defense will stipulate that there was prior calculation and design in committing the crime of aggravated murder.
We'll stipulate.
Very well. All right, the parties then stipulate that the element of prior calculation and design as being stipulated that the defendant did have prior calculation and design at the time of this incident. I think that's based on the fact that he made the statement that Allah told him to do it. He went over there, he looked for his father. I think he called his father out, and when his father came out, he shot him in the head, which is you can infer from the placement of the shot that he intended to kill him. State rests then?
The state does rest, Your Honor.
All right, state rests. All right, the court will admit by stipulation Defendant's Exhibit A. This exhibit is the original evaluation. I think it's 15 pages long. At the end of it, it's signed by Dr. Thomas Gaisley. This is the psychologist that is hired and does these reports for the Forensic Psychiatric Center of Northeastern Ohio, Inc. This is the expert that the state of Ohio normally would use, and this defendant was referred to the psychiatric center for evaluation. So, make a long story short, it's the state's expert that is found in this report that Mr. Riddle was insane at the time he committed this act. All right, any motions or anything of that nature that the parties want to make on the record? All right, the court finds, based on the testimony of the two police officers and under count 1 of the indictment, that the state of Ohio has proven beyond a reasonable doubt that on or about March 31st, 2013, and in the city of Ashtabula, county of Ashtabula, and state of Ohio, one Reshad J. Riddle did purposely and with prior calculation and design caused the death of another, to wit, Richard C. Riddle, who was then and there a living human being. And the court finds that the evidence clearly establishes that. The parties did stipulate to the prior calculation and design. The court also finds under specification of count 1 that the defendant did have a firearm on or about his person or under his control while committing the offense. In fact, the court finds beyond a reasonable doubt he used the firearm, which was identified as a Smith & Wesson .38 caliber handgun, to inflict a wound to the skull of Richard Riddle and to take his life. Now, the court finds that count 2 would merge into count 1 for any purposes of sentencing. And the court finds there was a third count of having weapons while under disability, and nobody's mentioned that count, so the court is going to find that the state has not proven beyond a reasonable doubt that the defendant had a weapon while under disability, and the court will order dismissal of count 3 of this indictment. Now, having found that the defendant, or the state of Ohio, has proved beyond a reasonable doubt all the elements of aggravated murder under count 1 of the indictment, the court now considers the defendant's affirmative defense of of insanity at the time of the commission of the act. The court finds that the only evidence that's been offered on that issue is the report of Dr. Gaisley, which was just admitted into evidence by stipulation. And the court also finds, as I stated a moment ago, this is normally the state's witness, so obviously the state of Ohio really didn't have any reason to ask, I don't believe, for a second opinion. And I think Dr. Gaisley is a reputable psychologist, and his opinion has been accepted. But the last paragraph, it continues to be my opinion with reasonable psychological certainty at the time of the offenses charged, Mr. Reshad Riddle suffered severe mental disease, specifically a psychotic disorder not otherwise specified. Because of the severe mental disease, Mr. Reshad Riddle, at the time of the offenses charged, did not know the wrongfulness of his acts. And I think one thing that's impressed me as far as the evidence in this case, leading me to believe the opinion of this expert, is that Mr. Riddle made no effort to escape, to evade. After this shooting, after he caused the death of his father, he went into the church and he stayed right there at the scene. Most cases where a defendant pleads insanity, the strongest evidence showing he was not insane is the fact that they fled the scene, they tried to hide and elude the police, knowing the police were looking for them, and they did something wrong. In this case, Mr. Riddle did not do that, and it causes me to believe that this opinion from Dr. Gaisley is an accurate opinion. I believe that Mr. Riddle was legally insane. The definition of legal insanity, I don't have it before me, but usually it's defined as being caused by a mental defect or disease and not knowing the wrongfulness of your act, not knowing the difference between right, good and bad or right and wrong. So the court is going to accept the opinion of Dr. Gaisley, and I find that although the state has proven all of the elements of aggravated murder, that the defendant has proved by preponderance of the evidence that he was insane at the time of this act and is therefore not legally responsible. So the defendant will be, the court having made that finding, under the law it's necessary now to schedule another evaluation with the mental health hospital, the behavioral health clinic, to determine what is the least restrictive means of confinement. I don't have the words here before me, but to determine just how the court is going to handle this. And the court did have a chance to discuss this with counsel before we started, and I think Mr. Pollack has indicated, and he can reaffirm it on the record, that he does wish to have this examination conducted to determine the least restrictive means of treatment. Am I correct in that assumption, Mr. Pollack?
You are correct, John.
All right. I believe the law requires this examination to be done within, I think it's 10 days. It may be a little difficult getting this done in 10 days with Christmas and New Year's coming up next week. A lot of these offices will be closed, but I think it's 10 working days and not 10 calendar days. So we'll try to get this rescheduled. Now, there's one other little complication. I'm out of office as of the end of December 31st. I'm age retired, so to speak. I was too old to run again. So if we can get this hearing scheduled no later than December 31st, I can go ahead and preside over it. For any reason it has to be scheduled after the first of the year, then my successor judge, which will be Cezanne, she'll have to conduct that hearing. It probably isn't going to be enough time for me to get appointed as a visiting judge in that short a time span, but we'll face that as we go along. The defendant back to the custody of the Ashtabula County Sheriff's Department. We'll contact the Forensic Center and get this examination scheduled. We're going to try to get it done within the next 10 days so that I can make the final ruling in this case. Mr. Vincent Arguin, the forensic monitor for this district, is present. Mr. Arguin, is there anything else the court should be doing at this point in time?
No, Your Honor, just as you said, to get that evaluation scheduled and a date set for the commitment here.
All right, maybe we'll call down this afternoon and see if there's any possibility, if we set this for the last day of the month, that they can get it done in 10 days and get it back up here. Mr. Riddle's been examined a couple of times. He was examined for competency. He's been at the behavioral hospital. He was restored to competency. He was examined again on the issue of sanity. So they're familiar with him and with his background. It shouldn't take an inordinate amount of time to get this commitment decision made.
Yeah, that's correct.
All right, so I'll go ahead and order that examination. No court costs will be assessed against the defendant because he has not been convicted of any crime in this case.
Hi, how are you? Lisa.
Let's go through.
Good, I want you to meet
Mr. Holman.
Mr. Holman.
Mr. Holman.
Susan.
Please step up.
Thank you.
Thank you, sir.
Sorry. I have that.
Officer, will you introduce yourself to the court and spell your last name?
My name is Patrolman Thomas Clemens Jr., C-L-E-M-E-N-S. It's Jr.
And for whom are you employed?
Ashtabula City Police Department. I entered the church with my service weapon drawn, and I could see the subject with his shirt off, with his hands raised to the ceiling of the church with a black revolver in his right hand.
Did there come a time that he said anything?
He was screaming to the church, "I'm the son of no one, I'll be praised."
What did you do at that point?
Ordered him at gunpoint to get onto the ground, at which time he began to turn and he placed the pistol down onto the glass